Good morning, First Deputy Speaker and honorable members. First Deputy Speaker, I'm rising to beg that we waive relevant standing orders so that we tackle government business. A, bills. This time around, First Deputy Speaker, Bill number 1 of 2022, Land Amendment. I beg to move.
Members, there is a motion on the floor that will vary all relevant standing orders in order for us to tackle 3 government business, A, bills, Bill number 1 of 22, Land Amendment. Those of the opinion say aye. Those of the good opinion say no. The ayes have it and the motion is carried.
Government business, item 3B1, bills. First reading, bill number 1 of 2022, Land Amendment.
Honorable Minister of Lands.
Honorable First Deputy Speaker, I beg to move that the Land Amendment Bill 2022 be read for the second time. I beg to move.
Honourable members, there is a motion that the Land Amendment Bill of 2021 be read a second time. Those of the opinion say aye. Those of the good opinion say no. The ayes have it and the motion is carried. Lands. Honourable Minister of Finance, of Lands.
Thank you. Mr. First Deputy Speaker, the bill before the House seeks to amend Land Act to, among other things, require holders of freehold title to develop their land within 2 years of the commencement of this Act, failing which the land shall convert to public land. The bill also provides that persons who are not citizens of Malawi shall only acquire land for investment purposes. Mr. First Deputy Speaker, as honorable members of this House may recall, in 2016 May, this House enacted a new and also amended other law-related pieces of legislation following a protracted land law reform process that commenced with a presidential inquiry on land reforms report issued in 1998 and the adoption of the National Land Policy on 17th January 2002. The 2016 land laws were the Land Act, the Customary Land Act, the Physical Planning Act, the Land Survey Act, the Registered Land Amendment Act, the Public Roads Amendment Act, the Forestry Amendment Act, the Malawi Housing Corporation Amendment Act, the Local Government Amendment Act, and Land Acquisition and Compensation Act. Madam Speaker, First Deputy Speaker, I beg your pardon. When the land laws were enacted in 2016, there were a lot of discontent with the laws by various stakeholders, including people living in rural areas, farming communities, traditional leaders, the academia, professional bodies, and civil society. The discontent was so much that even after the stakeholders were said to have been consulted and the bill tabled before Parliament, rushed and uncoordinated changes were made to the bills at the last minute, just before the bills were passed, to the discontentment and disappointment of so many quarters. As a result of the hurried last-minute changes to the bills, some of the pieces of land legislation ended up with drafting errors and disjointed provisions, rendering certain parts of the law not speaking to each other. And over time, voices of discontent became even louder. Mr. First Deputy Speaker, it is against this background that His Excellency the President, Dr. Lazarus McCarthy Chakwera, directed that all land-related laws should be reviewed, as he echoed the concerns of Malawians in relation to the laws in Parliament on 20th October 2020. Among other things, His Excellency the President expressed concern over ownership of land by non-citizens and payment of fees for registration of customary land by rural land owners. Mr. First Deputy Speaker, following extensive consultations with a wide range of stakeholders, the following major amendments were proposed. The Land Act of 1965 categorized land into public, customary, and private land. This categorization signified the overall management responsibility for each category. Section 7 of the Land Act of 2016 changed this and categorized land into private and public land. However, Section 19 of the Act provides for the registration of customary land into customary estates, which is defined as private land under Section 2 of the same Act. This change effectively abolished customary land in the sense that once all customary land will have been registered into customary estates, customary land will cease to exist. Yet, the Customary Land Act of 2016 was passed on the basis that customary land exists. So there was a contradiction. It has, however, been noted that there is no transitional provision to make customary land subsist until it is registered. In addition, considering the massive resource requirements to effect registration of customary land that comprises over 80% of land in Malawi, it is quite clear that customary land will exist for the foreseeable future. It must be noted further that it is an anomaly, it is anomalous to define communal customary land as public land, since it portrays a picture that the state intends to take over customary land on the pretext that it is public land. Mr. First Deputy Speaker, it has therefore been proposed that customary land should continue to exist as a category, and that Section 7 of the Land Act 2016 should be amended accordingly. All communal land, such as village forests, dambo land for grazing or dambo land for cultivation, communal grounds for sports or public events, should continue to be customary land under the jurisdiction of customary land committees. The definition of public land has been revised accordingly in Section 2. In essence, the customary land to be registered as private land is that which has been allocated to individuals, families, or clans. All land where public or government infrastructure is constructed, such as schools, clinics, etc., will be registered as public land. Mr. First Deputy Speaker, the House is informed that the National Land Policy, which was adopted in 2002, recommended that non-citizens should not be granted freehold titles. Rather, leasehold titles of not more than 50 years. This recommendation was first implemented through Section 24B of the Land Ammendment Act of Act number 6 of 2004 under Section 37 of the Land Act in 2016. And in addition, Section 11 of the Land Act of 2016 provides for the allocation of land for investment in Malawi and to be looked after by the Malawi Investment Trade Center, MITC, which would issue directive rights to investors in accordance with the Investment and Export Promotion Act. Consequently, a non-Malawian can only acquire land for investment purposes under Section 11 and for any other purpose under Section 37 of the Land Act. It is also possible, in view of the open language of its Section 11, that derivative rights that MITC can grant for investment can be used for an estate of more than 50 years. There is no rationale for granting land to non-Malawians for a purpose other than investment. So we're going to restrict it to investment purposes only. If the non-Malawian desires to reside in Malawi, they can obtain permanent resident permits under the Immigration Act or under the citizenship under the Citizenship Act. They should not have access to land for speculative purposes, as many absentee non-Malawian citizens are currently doing. Consequently, it is proposed that non-citizens should be allowed to acquire land for investment purposes only under Section 11 of the Land Act 2016. This necessitates the repealing of Section 37 and strengthening Section 11 of the Act to ensure that MITC has the prerequisites and the requirements enabling a mandate to administer and manage land for investment purposes. Mr. First Deputy Speaker, the House is informed that as the urban population grows and the demand for land for housing and commercial development is increasing, persons who were granted leases for agriculture around urban boundaries are making applications to change the use of land for agriculture or residential, from agriculture to residential, industrial, institutional, and commercial purposes. This change is not consistent with the initial objectives of the lease and the amount of land allocated for the developer. It is quite clear that these leasehold titles would not have been granted with such much land if they were for residential purposes, industrial, institutional, or commercial use only. The change of use, therefore, an opportunity for some lessees to make profits by selling undeveloped leasehold titles issued out of public land. This is against the provisions of the Clause 4.20 of the National Land Policy Act, which prohibits speculative hoarding of land. Consequently, it has been proposed that any application to change the use of land leased for agriculture purposes to residential or commercial development should be granted on condition that the lessee surrenders 50% of the land to government, subject to payment of the appropriate compensation, and that no sale of vacant land shall be allowed. Section 44 of the Land Act 2016 has been consequently amended to reflect this policy decision. Mr. First Deputy Speaker, the House is informed that some stakeholders have raised some constitutional questions in relation to this bill. One such being that restricting ownership of land to persons who are not citizens of Malawi violates their right not to be discriminated against on the basis of nationality under Section 20 of the Constitution. Let me address that one. The House is informed that the right to property guaranteed under Section 28 and 29 and 209 of the Constitution are subject to the Constitution itself and to legislation, meaning that the Constitution or legislation can restrict property rights. This is clear from the wording of these two sections, which prohibit arbitrary deprivation of property in Section 28, subsection 2, and that property rights acquired prior to the commencement of the Constitution shall continue under the Constitution and any other law, as Section 209 says. Mr. First Deputy Speaker, it follows, therefore, that the Constitution and legislation can restrict property rights. Firstly, constitutional rights can be restricted under Section 44 if prescribed by the law, if they are reasonable, and if recognized by international human rights standards and necessary in an open democratic society. Secondly, property rights can be restricted since they are not listed under Section 45 of the Constitution as rights that cannot be derogated from. Mr. First Deputy Speaker, it should be observed that non-Malawian citizens are allowed to own land in Malawi for investment purposes in accordance with Section 11 of the Land Act. In addition, the proposed restriction under this bill is in accordance with Section 44 of the Constitution, since it is prescribed by legislation. It is also reasonable since non-Malawian citizens have allegiances and priorities elsewhere. It also meets the international human rights standards, since almost all countries, they give priority to their citizens and discriminate against non-citizens in matters of access to basic resources such as certain scholarships, business fundings, or matters or other opportunities that are made available for citizens only. There is no reason to suggest that land, which is a basic resource, should be treated differently. It follows, therefore, that the proposed restriction is reasonable, it meets the international human rights standards, and is necessary in an open democratic society under Section 44 of the Constitution. Mr. First Deputy Speaker, let me end by reiterating that the proposal to restrict ownership of land to non-citizens for investment purposes only will ensure that land is used for productive and not speculative purposes by absentee foreign owners. This will free up land to be made available to Malawian citizens and meet the growing demand for land as the population grows. Mr. First Deputy Speaker, I therefore recommend to this House that this bill be accepted in this August House, and I invite all the members to support the bill. Thank you, Mr. First Deputy Speaker.
Thank you so much, Honorable Minister of Lands. May you switch off your... Okay. Thank you.
Thank you so much, First Deputy Speaker. The bill has attracted almost each and every member of the House who would like to make a contribution over that. But looking at our time, I would like to move that the debate on the bill be curtailed in order to allow the Honorable Minister of Land response to the issues that have been raised from members. I beg to move.
Thank you so much, Honorable Leader. Indeed, I know most members wanted to contribute, but we don't have enough time. My apologies. Honorable members, there is a motion on the floor that debate on the bill, on the land bill, be curtailed in order to allow the mover, who happens to be the speaker, to do the winding up. Those of the opinion say aye. I'm saying those of the opinion say aye. Thank you. Those of the opinion say no. The ayes have it, and the motion is carried. Honorable Minister of Lands, winding up.
Thank you very much, First Deputy Speaker. I would like to express my sincere gratitude to all the speakers this morning for the contributions towards Bill number 1 of 2022. A lot of very productive and also enlightening recommendations have also been made. Let me address a few of those. The DPP spokesperson talked about, the first one was actually a recommendation to the House that maybe we need to have the bills and the policies being circulated. That's a good recommendations, but at the same time, honorable members, you know, we have our own library in the House that we are supposed to use for any research purposes. So let's make sure that we make that provision. Let's make sure that we use that provision at the library for comparison with the policy and the bills. Secondly, in terms of surveys, there's an interesting point he talked about in terms of surveys and boundaries and so on. I mentioned one time, I was responding to say that the country, the whole of the country, we're now considering it to be, we're doing mapping, a mapping zone. So the issues of boundaries, where they begin, where they end, the encroachment and so on, they're going to be addressed because we're doing the mapping so that we can have all these in the land information management system, so that we do not have issues to do with the ownership of property, the boundaries, and so on. In terms of consultation with people, Constitution, Section 8 of the Constitution, you've actually noticed that this bill started appearing on day one on the order paper, and we're going to the end of the House, sitting 2 months later, simply because we wanted to exhaust the consultations. And actually, I've stayed close to 2 weeks. The last 2 weeks, no one has come up with concerns because we have addressed as much as we could. In terms of the amendments to development of the properties, that has been addressed in terms of the time period. It's already in the so that it's properly addressed in the amendments that are going to come. But generally, most of the comments, they are also going to be addressed in the implementation guidelines that go hand in hand with the act that has been, after it has been passed. UDF, thank you very much for your comments and agreeing to the bill. You mentioned a couple of things to do with to being in agreement. We appreciate your support. The issues of land ownership, that we've been working hand in hand with even the Minister of Gender to make sure that we address these issues. And for your information, there is the customary land bill, which is also going to be tabled, because most of the people who are vulnerable, they don't own land, are women, especially in the village. Now, with customary land laws provision having the land management committees, these committees are going to make sure that the women actually are entitled to own land, because they will have the document to prove that. But this is a working process to make sure that we have a definite things put in place to make sure that women own land just the same way as men. Issue of coordinating between Malawi Housing, city and lands, very true. It's an area that we need to go back to understand why land is owned by three entities.
Address the chair.
Why we need to, the three entities need to own land and not just one. We need to go back and do a proper research and see if we can do the proper amendments. Yes, I do agree we have a lot of problems in that area. In Zimba North, thank you for the clarifications and also enlightening us. He has a lot of experience when it comes to land issues and a lot of history. And I appreciate that a lot. Some of the comments that he made, they have to do with introduction of new bills. So I would like to encourage him, very wise recommendations, but I would like him to bring them as proposals so that we can introduce new bills or acts to speak to what he said. So I would like to, through you, to encourage him to do that. Yes, you can come for a cup of coffee. All right, and Ndunda system, it's addressed in the customary land bill that will be taken care of. Investment, because everyone who's coming in as an investor has to go through MITC. MITC has got the guidelines, so don't worry about that. So no one is going to build anything that is not supposed to be done. So thank you very much to everyone for the contributions, Zimba North, Rumpi West, Mapuyu, and the Lidongwensinja South. Therefore, I beg to move that the bill be read for the second time. I beg to move.
Point of order. Honourable members, there is a motion. I will recognize you, Chilezo South. Honourable members, there is a motion that the bill be read a second time. Those of the opinion say aye. Aye. Those of the contrary opinion say no. The ayes have it, and the motion is carried.
Government business, bills, report stage, Bill number 1 of 2022, Land Amendment.
Honourable Minister, reporting.
Thank you, Honourable First Deputy Speaker. I beg to report that Bill number 1 of 2022, Land Amendment Bill, went through the committee stage with amendments, and I beg to move that Bill number 1 of 2022 be read for the third time. I beg to move.
Honourable members, there is a motion that Bill number 1, Land Amendment, be read for the third time. Those of the opinion say aye. Aye. Those of the contrary opinion say no. The ayes have it, and the motion is carried.
Government business, bills, third reading, Bill number 1 of 2022, Land Amendment.
For Minister of Lands,
First Deputy Speaker, I beg to move that reading of Bill number 1 of 2022 be taken for the third time today and now and passed. I beg to move.
members, there is a motion that Bill number 1 of 22, Land Amendment, be read a third time and passed. Those of that opinion say aye. Those of the contrary opinion say no. The ayes have it, and the motion is carried. Therefore, the bill has passed. Congratulations, Honorable Minister of Lands, and congratulations, Honorable House.